Hi, I'm Jeff Hoyt, editor-in-chief of SeniorLiving.Org. It's a tragedy to lose a spouse or a parent, but when they pass, are you also responsible for paying their debts? Attorney Eric Olsen will explain the law to you and let you know that you have very little to worry about. Eric is the founder of the Helps nonprofit law firm, which educates seniors on how to maintain their financial independence. Due to social distancing guidelines, we will be conducting the interview online via Zoom. Hey, it's Jeff Hoyt here, editor-in-chief of SeniorLiving.Org. I'm talking with Eric Olsen. Eric's an attorney. He's the executive director of the Helps nonprofit law firm that helps seniors and others struggling with debt. Hi, Eric.
Hi, Jeff. Good to be here.
Great to have you. So we want to talk about what happens when someone in your family passes away who is in debt. For example, someone loses their spouse. Is there some sort of legal proceeding in a state or something that happens that the surviving spouse needs to worry about?
Normally not, and I'll explain why. Most spouses own their property jointly with rights of survivorship. Okay, if they have a home, if their both names are on it as jointly, sometimes they call it tenants by entirety, but they own it so that when one person dies, it automatically goes to the other one. There's no probate in that instance. There's no need to do anything. It transfers to the surviving spouse by operation of law. Now, the same thing if you had a bank account where you were on it with your spouse as a jointly on the bank account. When the spouse dies, then the money is the other spouse's. As far as the furniture and home furnishings, I think the law pretty much exclusively concludes that that's owned jointly, and then there's nothing needs to be done. I guess it's theoretically could be a little headache if, like, a husband had an expensive car and it was in his name only and there was no will. Then they have to go to the motor vehicles division to get the title changed, and they might have to do something in that instance. That could be a little complication, but it's solvable. It depends on the state where you live. But generally, when a spouse dies, there's no estate. The surviving spouse owns the property, and they go on from there. Now, of course, if there's a wealthy husband and wife and he had a business or something like that, it could get a little more complicated. But we're talking about, run of the mill.
And if the spouse who passed away had some debt just on their own, like a credit card in their own name, then the spouse would not be responsible for that debt?
That's true. And we'll talk about that. And that question comes up a lot. Okay, so a lot of spouses have credit cards in their own name. I do with myself. My wife has her own credit. I'm not on it. A husband and wife have absolutely separate credit reports. They're not combined. They're separate. And so if I passed away, my wife would not be technically responsible for credit card debt that I owe. Okay. Now, there are states that have laws called community property. I know you know what that is. It means that in some states, if you own a piece of property in your name alone and you're married, the law impugns that the wife has an interest in that property, half interest in that. Okay, even though it's in your name alone. And the same theory applies to a debt. Some interpret that law to say if the husband has a debt in his name alone, then okay, the wife is responsible for that with the husband. And that would be in a community property state. And they worry that if it's a community property state, they might owe the spouse's credit card debt, even though the credit card was in the spouse's name only that passed away. However, the credit card companies will never sue a surviving spouse on a credit card where, even in a community property state, where that surviving spouse name was not on the credit card. They weren't an applicant on the credit card. They didn't apply for it. They didn't sign it. They just don't do it. I've never seen it done in over 40 years of practice. I guess you could theoretically say it's possible, but for someone to try to say that is something that's going to happen or is something they need to worry about, I think that's misinformation. It doesn't happen.
Well, that's reassuring. Now, you mentioned an expensive car earlier. If I'm making car payments and my name is the only one on the loan, and if I pass away, now my wife doesn't owe the money for the car, but she would have to pay it if she wanted to keep using the car.
Well, yeah, that's right. Technically, in that situation, the wife could make a decision. Do I want to keep the car? Can I afford it? Keep making the payment. Okay. If she doesn't want it, she can say, sorry, pick it up, take it away. She's not going to owe the money on the car. She didn't have to worry about it. There might be in the contract something that would say that if the person that was responsible for that is no longer around, the creditor could call the loan or something like that. But that never happens. Creditors are just happy to get the payment every single month. They're happy. They don't care who pays it. If someone pays it, I don't care. So, I mean, if you draw that analogy out, if both mom and dad died and the kids kept making the car payment, even though the loan's not in their name, I mean, I don't think the bank or whoever finances is going to ever squawk. They're going to be happy to get the money. They don't want to repossess the car. They want the money.
So if the husband has a credit card in his name, the wife would not owe any debt. What if he makes her an authorized user of the card, though?
Good question. Sometimes credit card companies would use that as leverage to, I've seen it happen, to intimidate a spouse that they should have to pay that. But I've never seen a surviving spouse ever sued if they refused to pay it because they said, hey, my name was on that card, but I didn't sign for it. And, he put my name as an authorized user. I'm not responsible for it.
And are there certain ways that creditors can intimidate their surviving spouse to pay a debt?
Yeah, it happens all the time. It depends more of who the creditor is and what it's for. Credit card companies, not as much, but if a deceased spouse had a high interest loan, then they might try to pressure the spouse into thinking that they have to pay for it. And then there's the issue of medical debt, which we can talk about.
Please.
Okay, so if a husband and wife they're married, and it's often, if they don't have insurance or there's a deductible, and if one spouse incurs medical bills, okay, the question is, will the surviving spouse or the other spouse be responsible for it? Okay, and in many states, and probably most states, there's a principle, I call it the family purpose doctrine, and it applies especially to medical issues. If one spouse incurs medical bills, the other spouse is responsible for it. Now, that's not the case in all states, but in a lot of states it is. And so what that means is if you owe money to a doctor and you can't pay it, or a hospital, and they end up suing you, which probably isn't that likely for a senior for different reasons, for just because the senior's income is protected and all that kind of stuff. But they could sue both the husband and the wife together under the family purpose doctrine. But it depends where you live, and it doesn't always happen. And like I said, a lot of times the senior wouldn't be sued because their income is protected otherwise, like we've talked about. Their pension, Social Security, VA benefit, that income is protected by law. The hospital knows it. And then the other thing for hospital bills or medical bills is they have programs in place to forgive the debt for people that are indigent or can't afford it. Now, doctors are a little bit different, okay? They're more likely to try to pursue collection than maybe a hospital bill would. But once again, the spouse may be responsible for it with the other spouse.
And let's switch it around a little bit. If a senior, has a whirlwind romance and marries someone, and then finds out his new spouse has a huge amount of debt, she hadn't been vetted properly, let's say, is he responsible for her debt once he marries her?
No. But once again, good question. That a lot of people have that idea. They call me and they're worried about marrying someone because he's got this debt, and you're not responsible. Anything that was incurred before they were married, you're not responsible for it, period. And by the same token, if he incurs a debt for a business or, on his own and stuff, the new spouse who's not part of that isn't responsible for that debt. So no, they don't need to worry about that.
Okay, and let's talk about the next generation, children. Are there any cases where a child would be responsible for a parent's debt once they pass?
No. And although you might find articles on the internet that might tell you otherwise, and I'll explain why. Okay. So, and I guess you could think of one of a million, maybe one out of a million exceptions, but literally one out of a million. There's laws in some states called filial responsibility laws that apply to a child being responsible for a parent's medical debt, okay, or their care if their parent is indigent and not able to pay. Those laws used to be enforced, but now that we have Medicare and Medicaid, even though these laws may be on the books in different states, they're not enforced, because if you run up a lot of debt and you're poor, Medicaid covers you, okay? It's going to pay that. And, so there's really no debt. And if there is some, the creditor doesn't go after the kids. We just don't see it happening at all. Now, sometimes those laws are used to intimidate or scare a senior to thinking that they've got to pay this debt, because if they don't, the kids are going to have to pay it. And so it might be used by a debt management or debt settlement company to induce the senior to to secure their services to make payments, because otherwise their kids are going to be responsible for the debt. It's deceptive. It's not true.
Well, that's good to know. Now, what about someone who goes into assisted living or a nursing home? Could they go after a child for unpaid bills?
Okay, there's a federal law that mandates that nursing homes cannot have third parties co-sign for someone. So if you're a child and they say you need to sign on the dotted line that you're responsible for this for your parent, they're violating federal law. Okay, I don't see it happening, but it is possible, and we've seen it where a nursing home might put down that you're the responsible party. Okay, and so you're the one paying the bill, not the senior. You're the one paying the bill. So you're not co-signing. You're actually, and you don't need to do that. You don't need to be the responsible party.
So if you sign for it, you're responsible, but if you don't, then
you don't need. You don't need to sign for it. You don't need to sign for it. You don't need to do that. I mean, if this parent is poor and they can't pay for this, like they're going to go a memory care facility or anything like that, you contact the state, or frankly the facility itself will know how to put the parent on Medicaid. Okay, you've got Medicare, but if you're poor and you can't pay for your help, then the step up from that is Medicaid, where the government pays for it, and they're pretty versed on that. One little tip that might be good in this area is that if you have to put your parent into a nursing home, they're going to pay for it themselves. They got enough funds to do that, or assets. But eventually their money might run out and they might have to go on Medicaid. It's best to put the senior into a home or a nursing facility that accepts Medicaid patients. Okay. That way, if you're paying for it yourself, okay, and then the money runs out, the nursing home can't kick you out. They can't say you have to leave because you can't pay us. They have to accept you under Medicaid. But if the nursing facility doesn't accept Medicaid patients, then and you can't pay for it anymore, then they could require this person to move. So that's something that children should be aware of, or seniors should be aware about. It's best to get into a facility that might accept Medicaid patients. That way you don't have to move. Usually a little bit nicer facilities too.
So you seem to know a lot about debt and how to deal with it. Tell me about how the Helps nonprofit law firm can help people who are struggling with debt?
Half of seniors have incomes within 200% of the poverty line. They struggle with debt. A lot of them don't know what to do. Their income is protected. Social Security, pension, disability, VA benefits, protected by federal and state laws, can't be touched. But if debts aren't paid, debt collectors can call and make your life miserable. So there's a federal law called the Fair Debt Collection Practices Act. And one of the provisions is if a person is represented by an attorney, debt collectors can no longer call or send letters to that person anymore. And so what HELPS does is we're a 501c charity. We don't turn anyone away. We represent lower income or any senior that has debt they can't afford to pay, that's receiving Social Security, pension, protected income. We represent them as an attorney so that debt collectors can't bother them anymore. We send a letter to the debt collector saying, hey, we represent this person. Don't talk to him anymore. If you have any questions, call us. And so what we do is we represent seniors ongoing, literally for the rest of their life, so they never have to deal with debt collectors again. If they ever have any questions, they can call us on the phone. They get a newsletter every quarter. They get an email blast they can call us no matter how many times. They call us every day if they want. If they're worried or scared or have a question. If they get sued, we'll send a letter to the attorney saying, hey, take your judgment. Here's proof their income's protected. Don't bother them anymore. We talk to the senior. We get them information why they don't need to worry, why they won't need to go to court. And so that's what we do. And then we educate seniors on all the different topics on why they don't need to worry and how they can maintain their financial independence. Kind of a lot of the things we talked about today. That's just part of what we do. And we're the only nonprofit law firm in the nation doing what we do. It's very needful. This service is, seniors are so thankful when they find us. They're so grateful because there's really nowhere they can go to get answers to these questions. Most of the time, it's difficult. And they call HELPS. We can answer their questions, free them up from the debt collector harassment. And the most common thing they tell us is, peace came back to my life when I enrolled in HELPS. I don't have to worry about this stuff anymore.
Oh, great. So I hope to get the word out. And if people want to reach you at HELPS, how would they contact you?
We're all over the internet. It stands for Help Eliminate Legal Problems for Seniors. HELPS, nonprofit law firm. Got a great website. You can spend hours on it. www.helpsishere.org. Help with the S on it, ishere.org. Like you, we have a YouTube video with a lot of videos, but and then they can call us on the phone, 855 HELPS US, HELPS US, or HELPS US, or 855-435-7787. It's all the same. And we'll talk to someone, interview them, go over there. They can call us many times as they want and talk to them about their situation. If they want our help, we can enroll them. They can be enrolled immediately and protected from debt collectors bothering them instantaneously.
Fantastic. Well, thank you for imparting your wisdom and for taking the time, Eric.
Thanks very much for having us, Jeff. We really appreciate SeniorLiving.org and what you guys do to get this information out to seniors. Very appreciative of that. Thank you.
Well, thanks, because we couldn't do it without you.